at the Supreme Court of Canada on behalf of the International Human Rights Program at the University of Toronto. And we're here today as interveners in a very important business and human rights case, which is brought by Eritrean plaintiffs who are refugees who are bringing a claim for damages against a Canadian mining company called Nevsun Resources. And what the plaintiffs are alleging is that Nevsun partnered with the Eritrean state in order to develop a gold mine in Eritrea. And through this venture, Nevsun became complicit in a number of really egregious human rights violations committed by the Eritrean state and its military, including slavery and forced labor and torture. Now, there are two main issues in this appeal, but our submissions are focused on the active state doctrine. And the gist of that argument is that Nevsun is saying that the alleged human rights violations are all the sovereign acts of the Eritrean state. So in particular, the forced labor issue is the result of Eritrea's national service program. And Nevsun then goes on to say that the active state doctrine would prevent a Canadian court from judging whether or not the sovereign acts of the Eritrean state are illegal or wrongful. Now, a version of this rule exists in other jurisdictions, including the US and the UK and Australia, albeit all with really significant limitations. But this is the first time that a Canadian court is being asked to consider it in Canadian law. So our submissions this morning were targeted what the doctrine should look like in Canada, if it should be adopted at all, and in particular what its application should be in a dispute between private parties.
We intervened specifically in this case because of the broader human rights and business implications. We're concerned that if an active state doctrine is adopted, it would encourage businesses to partner with countries that have terrible human rights records and do business with them. And as soon as they're doing business with a foreign state, they will be protected from any claims made against them. So we're concerned both about this appeal itself, but also the broader implications on business and human rights generally.